This is Judge Todd Wong. I'm presiding in Travis County Court of Law Number 1, calling this hearing to order in cause number C1CV23-5561. Today's date is April 2nd, 2026. All right. If you would go ahead and make your appearance for the record, beginning with counsel for the plaintiff.
Good morning, Judge. My name is Ed Lee, counsel for Gonzalo Pacheco. He is sitting in today, but he won't be testifying or anything like that. He's just here for the purposes of observation.
Mr. Lee, this is as if you're in front of me in a courtroom. Do you think you'd appear in front of me without a jacket on? Go get a jacket on, counsel. Who else is here on behalf of the defendant?
Your Honor, Andrew Willard, on behalf of both Victoria Glen Homeowners Association and Robert Cruz, and with me is Jake Dima. He's another attorney with my office.
All right. Thank you very much. All right. As I wait for Mr. Lee to get properly attired for court. There we go. All right. Now we're all set. All right, so what I've got on my docket here is a motion for reconsideration of a defendant's motion for summary judgment from a while back, and then motion for sanctions due to some case law citation and other things that I guess the defendant wants to talk about. So there was a motion to also to object to a visiting judge, but y'all already agreed to one before, so you've kind of waived that. Doesn't really matter because I'm hearing the case right now. So that's really not on my docket. All right, so let's go with the defendant's motion for reconsideration. Either Mr. Willard or Mr. Dima, you may proceed.
Yes, Your Honor. Andrew Willard for the defendants. As I stated earlier, I represent both defendants, the Victoria Glen HOA and his former president, Robert Cruz. The plaintiff has filed a lawsuit against my clients asserting breach of contract, declaratory judgment, and a breach of fiduciary duty. The breach of duty is only against Mr. Cruz. Essentially, Mr. Pacheco is arguing that he's being incorrectly assessed his HOA fees by the HOA, and this is resulting in him being overcharged compared to some of the other residents. The motion for sanctions is being filed today because we had previously filed a motion for summary judgment seeking to dismiss all of Mr. Pacheco's claims as a matter of law because they are time barred. On November 25th of last year, we argued this motion in front of Judge Burgess. At that hearing, counsel for the plaintiff relied on and cited to multiple cases that either don't exist at all or to holdings and propositions of law that aren't actually in the cases that were cited. I'll get into this in a little bit more detail, but it was very clear at the hearing that Judge Burgess took counsel's citations as if they were in fact true, and then ultimately denied our motion for summary judgment. We're here today asking for relief from the court. Specifically, if the court's so inclined, we'd ask that the order denying defendant's summary judgment be vacated, the plaintiff's pleadings filed in response to the motion for summary judgment be struck due to the false and inaccurate case law. We'd ask that either our summary judgment be granted on the merits in its entirety, or that the plaintiff's claims in this case be dismissed as an appropriate sanction. And finally, if the court's not going to permit us to argue our motion for reconsideration today, then we'd ask that we be permitted to reset the summary judgment for a rehearing at a later date. Now, I'd planned on getting into a really descriptive explanation of what happened. However, plaintiff has filed a response to our motion for sanctions, I believe on Tuesday, or perhaps it was yesterday. In that response, just to summarize, counsel basically admitted his conduct, fell on his sword, and has addressed the issues, agreeing that there were false and fictitious citations. So I don't want to belabor that point, but I would like to walk the court through what happened to explain the nature of the prejudice to my clients. As I said earlier, we filed a motion for summary judgment based on the applicable statute of limitations, saying that these claims were time barred. Plaintiff then filed a response to our motion that I'm going to call the original response. And Your Honor, I don't know if you have a copy of our motion for sanctions pulled, but I'll show you Exhibit A from our motion. Basically, in plaintiff's original response to our summary judgment, he cited to a single case for multiple propositions of law, about 6 different propositions of law supporting his arguments. He even pulled a direct quote from that case. On my screen, that case is In re Christopher Kapmeyer. It's a 1-page opinion, but it does not contain a single one of the propositions of law that plaintiff relied on. Giving plaintiff counsel the benefit of the doubt, we searched for another case called In re Kapmeyer. We were able to locate it. There is a Supreme Court case with that name. The recorder and other identifying information is not what was cited in the motion or in the response. And this other In re Kapmeyer case only deals with, it's a joinder issue and does not contain any of the legal authority. So a week prior to the summary judgment hearing, we sent counsel a letter, which is Exhibit C, which I'm showing you, just explaining that, we were unable to find it. We think that, the citations are incorrect. And we asked that he either send us a copy of the case, send us the correct citation, or resolve the issue. We never heard back. All we got was a second response to our summary judgment, completely removing all citations to Kapmeyer and then citing a host of new cases. And in the second response, again, there were multiple issues, fictitious citations, what we believe are AI hallucinogen cases. And there was at least 3 cases that we identified that either a direct quote was pulled from that does not exist. The recorder number took us to a case that is not the case that was cited. And then there was another quote that did not exist. However, in our opinion, the most concerning case was a case called MBM Financial Corp v. The Woodlands, which plaintiff cited to as a Texas Supreme Court case. Plaintiff at the hearing in front of Judge Burgess stated affirmatively to the judge that this case recognized an ongoing economic breach as giving rise to a recurring cause of action, essentially arguing that every time Mr. Pacheco was assessed, it either told or reset the statute of limitations. This case does not mention that. Counsel made the affirmative representation at the hearing that this case was Texas Supreme Court case law. It was controlling law. The reason that this case is so important, that due to its miscitation, and in fact, that case really only stands for the proposition that attorney's fees can be awarded in addition to nominal damages or something along those lines. And that doesn't even talk about this recurring violation rule, which again is not an actual Texas doctrine. But at that hearing, once this case was cited, I brought it up to Judge Burgess and said, Your Honor, I should have addressed this probably at the beginning of the hearing, but we believe the citations from this case are false, or there's hallucinogens or any of the hallmarks of generative AI being used. I don't think the judge understood the allegation that I was making, because his next question to me was essentially, well, do you have a Supreme Court case that rebuts that proposition of law? And then shortly after that, he denied our motion after we had a discussion about whether the continuing violation doctrine existed or not. I've never had to file a motion like this before, and I don't enjoy doing it now. However, just the fact that the original response was filed with fake cases, we informed counsel that the cases were fake. A second response was filed with fake cases. We did not inform him because it was right before the hearing. But then the fact that, it was doubled down on at the hearing in front of Judge Burgess and clearly was a deciding factor in our summary judgment being denied. We wanted to bring this to the court's attention and show that our client has been prejudiced, because the issues before the court on the summary judgment are very clear. It's just statute of limitations. And there's very clear case law that, if we're allowed, Mr. Demo will explain to you, Judge. And so essentially we're here. We cited a whole host of cases in our motion for sanctions addressing, what the hallmarks of AI generated case law look like. And then also what courts in the Northern District of Texas, Eastern District, and then some other circuit courts have decided are appropriate sanctions. And so today we're asking that the court, again, vacate the order denying the motion for summary judgment, strike plaintiff's pleadings, and grant our summary judgment, or dismiss this case as an appropriate sanction. And then alternatively, if the court's inclined to have a rehearing, permit us to rehear, or permit us to argue our arguments set forth in our motion for summary judgment. And that concludes my argument, Your Honor.
Thank you, counsel. Are you asking for attorney's fees?
We've asked for attorney's fees just to cover the cost of the original hearing and today's hearing on the motion for sanctions.
Did you submit an affidavit?
The court's so inclined, we'll submit an affidavit.
So you have not yet?
We have not, as we need to calculate our fees from today. And granted, I understand we have 2 attorneys here, so I'll be conscious of what I think is appropriate. But Your Honor, at the end of the day, my client and myself, the attorney's fees are not what we're after. We're here to get justice for the defendants. And based on these clear time-barred causes of action, we're essentially asking just for judgment in our favor. And we're willing to, waive attorney's fees if we can just get this case resolved through summary judgment or through a dismissal as an appropriate sanction.
All right. Thank you very much. All right, Mr. Lee, what do we have here?
Judge, can I ask for the screen sharing to be cleared so that we can focus on the conversation, please? Thank you. So, Judge, I want to address it directly. I put it in my response. The earlier filings did contain citations that I didn't verify properly. It shouldn't have happened, and I take responsibility for that. The issue is twofold, however. One is the citations may have been wrong, but the principle of law is correct, and that's addressed in the response to the MSJ on the merits. And the other issue is really whether this rises to the level of sanctions. The legal standard under Rule 13 and then under Chapter 10 is that the pleading is both groundless and brought in bad faith for the purpose of harassment. Also, there's a presumption of good faith, and sanctions require conscious wrongdoing, not just mistake or negligence. I think the facts as described don't show conscious wrongdoing. I do believe that they show mistake or negligence. Chapter 10, similarly.
Mr. Lee, let me interrupt you for just a second. Did you use AI to come up with your response?
I did. I used several tools in order to do the research. The drafting that I draft by hand myself, but I do use available technology in order to do my work.
So you understand the obligation of counsel, if you're going to utilize AI, is to actually check the citations and the quotations that the AI provides.
Totally understand that, Judge.
If you were in federal court, what do you think would happen?
Judge, I can't quite say. I don't practice in federal court. I'm sure it wouldn't. I'm sure it would be as uncomfortable and difficult as it is right here today. It's a situation that I never wanted to be in, but the fact is, I'm owning it, and I do believe that this case should be heard on the merits. I do believe that there is a good faith argument for everything in terms of the merits of the case. I've even offered, we offered to have a redo of the summary judgment. I offered to, an agreed motion to vacate, a reset, and they said no. They said they wanted to push the sanctions. I understand that, but, if Mr. Willard is talking about justice for his client, I think that there's more at stake here than just his client. There's my client and there's the entire community that are similarly situated. These are things that the defendants have an opportunity to correct, and they just choose not to. To be able to dismiss this without consideration of the merits based on my mistake, the death sentence sanctions are rare, as you know. Again, the facts show, and I'm representing to the court today. I did make a reasonable inquiry. I did take corrective action at the time of the filing. I didn't independently verify that because it was such a truism that, you can't have a summary judgment on,
Don't start justifying using AI and hold on. Do not interrupt me, counsel. Do not attempt to come to me today and try to justify putting false information, false case law before the court, whether it's before me or Judge Burgess or anyone else. Don't do that. I just need to know.
Understood.
The basis for even having this go on further, because the sanction issue is real, okay? I'm definitely considering sanctions. I don't think it's appropriate that you come now today saying, well, yeah, that was incorrect. I didn't do it right. That is a fundamental issue for lawyers. I mean, the public's trust in the justice system is that the lawyers will dutifully provide case information, court precedent, and cite it correctly. That
Yes.
You understand that. And so it's very difficult for me to stand here today and listen to this and not think that the sanctions should be very severe to you.
I understand,
you may continue,
Judge.
okay?
Thank you, Judge. I'm not going to minimize it. I started out the conversation by saying I'm not going to minimize it, and I'm sorry that it came across that way. That was not my intent. I look at this as what's proportional, what is needed to right the wrong. I do believe that rehearing on the summary judgment is appropriate. And I do believe that, to the extent that I've attempted to cooperate with making that happen, should show some good faith effort on my part to remedy the wrong. The other thing that I will say in closing is I've completely revamped my research tools and the ability to get accurate and timely case law. Just to let you know, it's a LexisNexis platform, and that I think is a benefit to me. This is not something that's going to happen again. I will tell you, I never want to disappoint you or any other judge, and I never want to put opposing counsel in a position where they've had to do an uncomfortable situation, which is, call me out and bring me to task. So, Judge, I'm asking and I'm arguing that it wasn't intentional. It was terrible, but I don't believe it rises to the level of a death sentence sanction.
Anything else, Mr. Willard or Mr. Edema?
Yes, Your Honor. I will say that, the purpose of the day's hearing was not to hang Mr. Lee in the court of law. The only reason that we brought this was to ensure, one, that justice was done for our client, and two, to make the court aware should this case continue into the future, just so we did not get down the road and have these issues arise a second or third time and have the court question us as to why we never made it known at the outset or when the first time happened. But that's it, Your Honor. That's it for me.
All right. Thank you. I appreciate the courtesies. All right. Here's what I'm going to do. Well, I'm looking at even the original motion for summary judgment, and I haven't had a chance to have y'all do a full argument on it. You've already had that heard by Justice Burgess. I'm going to do this. One, I'm going to vacate the prior summary judgment rejection by the court. I'm not striking pleadings. I'm going to order all attorney's fees incurred by the defendants to have their hearing on the motion for summary judgment, not the preparation of it, not the first one anyway. They're not going to need to be reimbursed for that, right? But I do need the attorney's fees incurred from the hearing date itself, because before that hearing, y'all gave him an opportunity to clean it up. So I'm not going to charge those fees or assess those fees, but the fees incurred for the hearing itself and the subsequent hearing prep for the hearing today, the instrument to file, and today's hearing, those fees need to be put into an affidavit. I'm going to award those fees, assuming they're reasonable and necessary. I'm going to have y'all have another rehearing on the motion for summary judgment. And since I'm going to go ahead and assess the fees that were assessed for the original one. I'm not assessing it for the second one, but I do need to have an affidavit on those fees. So we're going to reset it. I'm striking the response to the summary judgment that was filed by the plaintiff. And he's going to have to actually refile or resubmit an answer or a response to the summary judgment motion. Yes, sir.
Just for clarification, there have been 3 responses filed by the plaintiff. Are you intending to strike all 3?
Those are all strict. I want an actual clean response to the motion for summary judgment.
Judge, I'd be happy to provide that. Thank you.
All right. Let's see. I'm going to reprimand counsel, Mr. Lee, for utilizing AI and not actually researching any citations that were submitted to the court. For the response to the summary judgment motion, every single case you cite, sir, you shall include either a link to it electronically or the physical copy to both the opposing counsel and to the court. If you cite any case, they have to be provided.
Understood.
For this reply. I want it highlighted. Hold on. And if you're going to do any quotations, they need to be in your response. They've got to be highlighted in the actual text of the case law that you are using.
Yes, just to be clear, is it okay if I use the hyperlink to the site to the actual case within LexisNexis?
So long as Mr. Willard and Mr. Dema can access it, they may not use Lexis. They may use Westlaw. I don't know.
Understood. I'll coordinate ahead of time, Judge.
Copies of every case. I think it's a pretty narrow issue, whether statute of limitations under it looks like Dunhuang Plaza Association versus Sun 9028, 693 Southwest 3rd, 811, talking about when that time trigger starts. I'm not going to get into the details of it. It just looks like that's kind of a big issue as far as we're just looking at limitations. So if there's some contrary case law to that, great. But don't ever do this again.
Yeah, Judge, never happen again. One thing that I do want to preview for you is, they're saying it's an orange. I'm saying it's an apple. They're claiming.
Please stop it. Please stop. Just respond. I don't need to hear that now. You can make that argument in your response to the summary judgment motion. I don't need to hear it today. I'm only going to give you all a limited amount of time to get this done because this has been rolling around for months, and I don't like my cases to sit. And even though this was in court too, and I'm hearing it today, it's not sitting. So you've got. Why don't you work with Ms. Colton? She'll be able to have access to both. Well, to our court schedule and see if we can get you in. In the meantime, I'm expecting Mr. Willard to go ahead and send the affidavit for the attorney's fees and then send over the proposed, just the order from today's hearing.
Yes, Your Honor.
All right. Thank y'all very much. Appreciate it.